Nothing on the show is to be construed as legal advice. The contents of this show are for informational purposes only.
Hello, welcome to Know Your Rights, the Consumer Lawcast, with me, your host, Abbas Kazerounian. So, welcome back, everybody. Thanks for being here. Today, we're very, very lucky. We've got a very special guest, Mona Amini, Kazerounian Law Group attorney, a bit of a veteran, and the topic that we're going to be covering today, it's immense. I really want you to pay attention. This is probably one of the most important podcasts that we're going to put out there because it is about the Fair Debt Collection Practices Act, or the FDCPA. It is about telling you, the consumer, about your rights as it pertains to debt collection activity. What a lot of people don't know in the United States is this. When a debt collector tries to collect debt from you, they have certain obligations and duties under the law. They can't just call you or write to you and willingly collect. And Mona here is going to help me educate you today about what your rights are. Because even if you owe the debt, and I'll repeat that, even if you owe the debt, you may have a lawsuit. And like through our experience, because we do a lot of this kind of litigation, about maybe 70, 80% of the times in certain areas, when somebody's trying to collect a debt from you, they're probably breaking the law. And the only reason that nothing happens is because the consumer doesn't know their rights. Isn't that right, Mona?
That's right.
So thanks very much for being here, by the way.
Thank you for having me today.
Now, before we get into the weeds, I got to talk about this. I just want to talk a little bit about a bit of legal gossip, and I know the consumer probably doesn't really get into the weeds about the law, and I told you on our very first episode, I'm not going to get into the weeds about the law, but this is just too funny. So in the Second Circuit Court of Appeals, which is the second level of kind of our courts, when somebody loses at the lower courts, they appeal it to the Court of Appeals. And the Second Circuit is one of the circuits. So there was a case. Do you know the story here?
No, why don't you tell me?
All right, so this is what happened. So what happened is, what you do is you submit briefs. So you say, judges, this is our legal position. So then they give you a date to show up for oral argument to orally advocate for your client. So this clown shows up and says, you know what? I don't even know why I'm here. Everything that I've said to you is in my brief, so I'm not sure why I'm here. And they're like, well, let me ask you a question. And he almost started patronizing the judges and was like, you know what? That's almost like a stupid question. You probably didn't read my briefs. And they got really, really angry at him or pissed at him, and they threw him out of court.
Wow.
Yeah, so, and I told you, to consumers that probably doesn't mean a lot, but if there are any lawyers, they'll be like, woo. So anyway, after that piece of mindless gossip, let's get to it. The Fair Debt Collection Practices Act. This is a statute, guys, that was created in 1977. It's 1977. And I mean, in the biggest spectrum of things, Mona, this is a pretty old law.
It is.
I mean, pretty new law. I beg your pardon. Let's go that. She'll just say yes to anything. So it's actually a pretty new law. But it's not a well-known law. And there are two policies why the FDCPA was created. So why don't you tell the consumers and the viewers and the listeners out there what the main policies behind the creation of the Debt Collection Act is?
Sure. So one of the main reasons that the FDCPA was enacted was to protect consumers from overly aggressive debt collectors. And that's huge because without that, that wouldn't keep debt collectors in check. There are some that follow the law and there are some that are really egregious. And that's the reason why the FDCPA exists, to protect consumers from those sorts of debt collectors.
Right. And I think that is like what most people would think of is, to protect consumers. It is a consumer statute. But a lot of conservatives in our nation give a lot of pushback on this statute, right? And they say, you know what, these people are deadbeats, they owe money, they should pay their debts. But even though I strongly, this is just my personal opinion, think that's just the ridiculous way to look at the, ridiculous view of the world, there is actually a conservative policy also that is the underpinnings of the statute. So if you're somebody in debt and you have these conservatives pushing back on you going, well, this is a nonsense law, that's not the case. Because, do you know where I'm going with this?
I think I do. I think it's that, this law also protects those debt collectors that are doing it right. They're the ones that should stay in business, and these ones that are, making it more difficult for them to run their business, should be the ones that are not doing it. The ones that are following the law should be the ones going ahead and collecting from consumers by, honoring their rights and everything, and the ones that are not are the ones that should probably go by the wayside.
It's absolutely right. And to say it another way, it's actually a capitalist theory here, right? Which is this, that the law was created to put businesses that are doing it the right way in an equal playing field. It's about competitive disadvantage, because if there are these unscrupulous debt collectors that send heavies to people's houses, start using racial epithets, violence, swearing, and all this kind of stuff, it puts the more honorable and the more the debt collectors that are doing it the right way at a competitive disadvantage. And what we want in all business in America is to allow businesses to compete on a level playing field. And so what the law does is it allows us to check these unscrupulous and bad actors so that they are punished for their bad conduct, so that the good debt collectors, is there such a thing? But the good debt collectors on a level playing field. And so if there are any conservatives out there that think this is a nonsense law, well, think about it that way.
That's right.
Right? So let's get a little bit more into the weeds. Not legally, just from a layperson's perspective. So we talked about a little about the policy. Now, what is a debt collector under the purview of this statute, Mona?
So a debt collector is a company that basically is collecting debt for itself that it either acquired for another company or may own itself.
Right. So we're talking about a third party, right? Okay. So if it's the original creditor, can you give some examples of the original creditor?
Like a bank, a loan company, something like that could be the original creditor.
And they are not a debt collector?
That's correct. Not under the FDCPA.
So give us a hypo of a debt collector.
By name?
No, not by name. I mean,
So-
we can name some. Like Midland Funding, for example, is one of the biggest ones in the country.
Sure, there's a lot of big ones out there, but the typical scenario is, let's call it, Mr. Debt Collector buys an account from the bank or maybe a previous debt collector, and now they essentially say that they've stepped into the shoes of the original party and they want to go after the consumer for the debt, but in reality, they've actually purchased the account for pennies on the dollar, and they're hoping to reap the full profit for their own purposes.
That's good. Lee, you actually touched on something that I think is really, really important, which is about the education of debt, and we'll come back to that. And by the way, if anybody is really into this and wants to learn more about debt collection, we're not going to go into it more, and I'm probably going to try and invite the author of this book. It's called Bad Paper. If anybody's ever not read it, is interested in debt collection, read it. It's just absolutely enthralling, and it will be an education on how the debt industry works. And I'm a big fan of that book. But outside of that, and I want to come back about the pennies on the dollar that you mentioned, but before we get there, so let me just bring you a full loop. This is really important, guys. So the FDCPA, third parties only. So let's have a hypothetical original creditor, Bank of America, not a debt collector, right? So Bank of America can do one of two things. Once you are in debt and they've tried to collect from you directly, doesn't cover it. But then they can choose to do one of two things. They can say, we're going to charge the debt off and sell it to a debt collector or a debt buyer who will then in turn try and collect on the full amount of the debt. Or they can still own the debt but hire a third-party debt collector to collect. Now, once one of those two things happens, this statute is triggered, right?
That's right, yeah.
Okie dokie. Woo! So, let's get into what you kind of mentioned right now. And the thing is like, there's a big misconception that these third parties are, trying to collect the entirety of the debt, which they always do, and they always tell consumers, you owe this money or whatever, but if ever a debt collector is contacting you, do not be afraid to negotiate. And I'm going to let kind of Mona expand on what she was talking on about before, because these guys did not pay full value for this debt. And the original creditors already charged off this debt and got the tax write-off for it. And on top of the tax write-off, they've profited by selling the paper, or the debt, it's called the paper, for additional profit for pennies on the dollar. So can you expand on that a little bit, Mona?
That's right. So like Abbas said, oftentimes the creditor, like the bank, is going to charge off the account from their books after some period of time where they've decided this consumer just isn't going to finish paying on this account. So they've essentially wiped their books of it. That doesn't mean the debt's gone. It just means that, Bank of America, if you'd like that example, isn't expecting to get paid on that account anymore. So at that point, oftentimes, that account, along with a batch of many others that may have been charged off that year or within some period of time, gets sold off to a debt collector, which is a third party, that then would own that type of an account, and they would be collecting for themselves. That money that, the debt buyer or the debt collector gets from the consumer isn't really going back to Bank of America or the bank that originally owned the account. It's actually going to the debt collector.
Right. Listen, guys, I think the takeaway as far as this particular point is this. Even with original creditors, when anyone's trying to collect from you, and let's assume they're not violating the law, and we'll get into why they probably are, but let's assume they're not. Don't ever just think you have no bargaining position, because it's just not true. Mona and I have worked on these cases I've done it for over a decade, right? And Mona's done it for close to a decade. And one thing you will find is that the purpose of the person trying to collect the debt, whether it's the original creditor or a third party, their job is to try and get as much cash out of you as possible. And they probably assume and presume that you can't afford the entirety because you would have paid it already. So don't necessarily just assume that you have to pay the entire amount. You have bargaining power, meaning you can fight back and say, no, I can't afford $10,000, but I'll give you $1,000. And they may not take the $1,000, but that doesn't mean that's the end of the conversation. They may say, you know what? Okay, I'm not going to take $1,000, but I'll offer you $9,500. And then you can go, well, no, I can't afford $9,500. I'll give you $1,500. And then don't just assume you have to pay it in one lump sum. What other options do they have?
That's right. So oftentimes with that back and forth, consumers are surprised that the debt collector is often willing to take less than the full balance. And oftentimes they're willing to do it on a payment plan, no interest, something the consumer can comfortably pay, maybe a little small portion a month, maybe $50 a month for maybe a year, maybe more. And that really puts power back in the consumer's hands, that they can manage this account now. They don't have to worry about the debt collector, coming after them, sending them letters, calling them anymore. They've decided to settle it for, a fraction of the original amount, and they're willing to do it on a payment plan. You don't have to pay any more interest on that debt either.
Sure. And, a lot of people choose to have attorneys, and, the point of this podcast is not to say you need an attorney for everything, and you do need an attorney for a lot of things. But I'm just trying to explain to you, and Mona's trying to explain to you, just what your rights are, and the fact that you shouldn't be scared to try and negotiate with these big entities. And, good on you if you do. And we've had clients, for example, that literally they've owed a couple of $1,000s, and we've put them on a payment plan that the plaintiffs, which are these banks or these debt collectors, have agreed to at something like $50 a month to pay off like $3,000, $4,000, $5,000, $6,000. That could take years, but they've agreed to it because you have leverage in the fact that you can't afford the money. Because what are you going to do? You can say, I can either give you nothing and file bankruptcy, or I can give you what? $50 a month. What do you think they're going to take? They'd rather have a bird in the hand, right?
That's right.
Anyway, and I think that's actually a very important conversation, though it's not directly related to the Fair Debt and Practices Act. I think the fact that you should know your rights about your power as a consumer is important. But let's get into the FDCPA. So, listen. There's probably a million ways that anyone can violate the FDCPA, right?
Sure.
And we can't possibly get into all of them, but I think it's important to go over it for the viewers and the listeners, what the big sort of the things that we see most frequently across our desks in this area, in this field. So why don't you explain a little bit about the timing of when debt collectors can call and not call?
Sure. So debt collectors can call you, but not before 8 a.m. or after 9 p.m. These calls need to fall in that sort of normal period of the day where people would be awake and not disturbing you in the middle of the night. So after 8 a.m. and before 9 p.m. are when debt collectors should be calling.
8 a.m. is early, Mona.
Well, that's when the debt collectors are awake, so they're hoping you're awake too. So oftentimes they'll call just after 8 a.m., But sometimes if they're maybe in a different time zone, or if they've, had an oopsie on your account, you'll see debt collectors calling you at 5, 6 in the morning, and that would be a violation.
So what do you mean by that? Like, explain the time zone thing. So do you take the time by where the debt collector is or by where the consumer is?
No, it's your right. So wherever the consumer is located is that time zone. So if you're located in California, it should be Pacific Standard Time. If you're on the East Coast, it should be according to that time zone or wherever you happen to be residing.
Okay, so if I get a call at 7:59, do I have a case?
I mean, it's a close one, but technically, yes. And that's one of the other things about the FDCPA is that, it's a strict liability statute. So
No legal talk!
that means that it's not them accidentally or purposely doing it the wrong way. If they've done it wrong, and they violated the FDCPA.
Right, so in layperson's terms, I think what strict liability means is if you break it, you pay for it.
That's right.
And in a criminal context, there are certain statutes that are like strict liability, and I think the most well-known strict liability statute is statutory rape. It doesn't matter that the person in question that you had sexual encounter with is had a fake ID or something like that. It's strict liability. You
right.
commit the crime, you do the time.
That's right.
So that's an example. So that's in the criminal context. And in the civil context, the Fair Debt Collection Practices Act is a strict liability statute. It doesn't matter how close to the line it was. If it's over the line by a millimeter, it's a violation.
It's a violation.
Okay, so I just thought of something. I'm going to use my pen. Hold on.
It's real, guys.
It's real. I have thoughts. So here we go. Okay, so we talked about that. What about the volume of calls, Mona?
The volume of calls. So there isn't necessarily an exact number, but certainly if you're being harassed by a debt collector, back-to-back calls throughout the day, from morning to night, that could be considered a violation.
Well, I don't know. I think we get more specific than that. So you're right? The statute, and by the way, the statute, the FDCPA, for those that are interested, and I know a lot of consumers will actually want to look at it in hard black and white, in text. I mean, if you put it the FDCPA, it'll probably pull up on Google anyway. But notwithstanding that, it's at 15 USC 1692, section 1692 of 15 USC. Again, the purpose of this is not to confuse you with legal jargon. If you just put in Fair Debt Collection Practices Act, it will come up. But the statute itself doesn't, as you said, have a magic number in it that says if you call X amount, it's a violation.
That's right.
But I think we have to be a little bit careful in educating you here a little, which is this. And again, I know we advise you at the beginning of every podcast, this is not legal advice, guys. This is just for information. So please, respect that. If you have a question, call a lawyer in your area, and they'll help you. But just informationally, this is from our experience in litigating these cases. The statute doesn't have a specific number. But in my experience, I think the number that amounts to kind of harassment level is 8. Now, I'm not just it's just through experience. I think if you have 3 or 4 calls, it doesn't mean it's not a violation. And there are scenarios, it's case specific, is what I'm trying to say.
I think so.
But assuming that someone calls 8 times, it begins to become potentially a case. But if it's just one day with 8 calls, I think you would agree that it's a tight call, right?
I think so, right.
But if you have 10 days of 8 calls a day, that's 80 calls in 10 days.
Right, and I think it's also important if you did maybe answer any of those calls and maybe told the debt collector, I can't pay it all this month, or, don't call me today, I'm at work. Or if you told them something that should have prevented those calls from happening, I think that's where it's important to maybe take notes and, keep a record of when these calls happen and what you told them, and then you'll go from there. And maybe there is a violation, maybe it's not, but I mean that's when the lawyers come in and they take a look at the facts.
I gotta tell you, war story time. So I had a case, and we won on this, right? So it was a scenario where there were multiple calls, but there was one day in question. There were only 5 calls. Mm-hmm. But they called the debtor, and he owed the money, by the way. Like I told you, it doesn't matter if you owe the money or not. It's how they collect. That's what's important. So don't be misguided. There are scenarios where they try and collect on you and you don't owe the money. That's an absolute violation. But just because you owe the money doesn't mean that they're not violating. And you absolutely have, and when we started practicing this area of law, by the way, judges were literally like, hold on a minute, your client owes money and you're suing them. I'm like, yeah. And they're like, huh? And we had to educate judges, right?
That's
and
right.
so like, it's actually in certain areas of the country where this kind of litigation doesn't happen, it's hard actually convincing the judiciary that these people have rights. Back to the story. So I had a client, he gets a call at like, let's say 8:30 in the morning. I don't remember the time, but let's just go with it. And he picks up the phone and he says, yes, I understand I owe this money. I'm sorry, but I'm out of work right now. I can't pay you. It's like, okay, thank you very much, blah, 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 blah. Well, 30 minutes later, lo and behold, the same debt collector calls our client. Well, what the fuck happened in that 30 minutes? And you can bleep me out, I don't care. I mean, seriously, what could have happened? He won the lottery in 30 minutes. What other purpose could that guy have had to call my client in 30 minutes later, but for the fact of harassing him? It just makes no sense. Now, in that scenario, they called 3 more times after that, and we won the violation. Because in that case-specific time, case-specific case, 5 was excessive because we had a picked-up call with an explanation, which was in their account notes, by the way, that said, I can't afford to pay you. So there, it makes sense that they're only calling to harass the guy. But imagine the same hypothetical, but my client didn't pick up the first call, and he just got 5 missed calls. Then I think the debt collector in that scenario has a fair point to say, well, I'm trying to get hold of the guy.
Sure.
He's not picking up, right?
Sure.
So it's case specific. But going back to your point, there is a portion of the FDCPA that says if you have a voluminous amount of calls with the intent to harass, and that portion is important, and that's why it's case specific, then you have a violation.
Mm-hmm. That's right. That's right.
I'm getting very excited today. This is one
the
of my...
FDCPA excites him.
It really excites me. Okie dokie. That's the second time I've said that today. Okay. Cease and desist. Educate me.
So cease and desist, or more plain language, is telling a debt collector to stop contacting you. So for that cease and desist under the statute to be valid, it needs to be in writing. It doesn't need to be sent snail mail. It doesn't need to be any particular words or anything like that. You don't even have to say cease and desist. You can send them an email, a fax. If they text you, you can text them back.
Well, you know what? Let's get to the method of delivery in 1 second. Let's talk
Sure.
about the content.
Sure.
What has to be in it and what doesn't have to be in it?
Well, no law or special magic words need to be in it other than stop contacting me, maybe reference the account, because debt collectors might handle several accounts for you if you are a person in debt. Or, they won't know what account belongs to you if you don't tell them what account it is. So maybe that, if you don't know your account number, maybe the last 4 of your social could help, something that ties you to this account that they've been contacting you about. And you can tell them to stop, I won't pay this, I don't want to pay this. There's a few ways you can say it, but the point is to get the message to them that you don't want to be contacted anymore.
I think there's a lot of takeaways from what Mona just said. As a practice tool, what we educate our clients with is the following. Number 1, if you have the account number and the name on the account, so as your name appears, let's say it's a credit card debt. If your name is, for example, John M. Smith on your credit card, say reference John M. Smith, and then account number, exactly what your account number is, up at the top in the reference line. Then don't get cute, don't get fancy, don't start citing to, according to 15 U.S.C. 1692 at 6 subsection blah, 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 blah. Because first of all, you're flagging it for them. Don't do that, okay? Second, just keep it simple. Because the law doesn't require you to cite to a statute. So why do it? Why make it more complicated for yourself, right?
That's right, yeah.
I mean, literally, I tell my clients, keep it simple, and this is the kind of language that I just say. To whom it may concern, Do not contact me in any way, shape, or form regarding the above referenced account or any other matter, including on my cell phone. Lots of love, John Smith. Now, rewind it back on the YouTube and you can get that language back. But if you have that, you're covering yourself for the FDCPA, and if they contact you after the fact, it's a violation.
That's right.
And if they use an auto dialer, it's also
Maybe a TCPA violation.
bingo. And we're going to have a whole show on TCPA as well at another day. That's the Telephone Consumer Protection Act. But under the FDCPA, that is it. Now, we've only got like 3 minutes before we have to change the tape, but let's talk about the methodology of sending it, of the cease and desist letter.
You mean how to send it?
Yeah, what's the best and most effective method?
I think if you want to be extra safe, you send it to the address that you know is correct, certified mail. You don't need to send it with signature confirmation or anything complicated. But if you send it certified mail, first of all, you'll be able to track it to know that it got there. And then one day down the line, if they say they never got it, you'll have that certified mail receipt that says that they received it on whatever date and it was signed maybe by somebody when they received it.
And in fact, don't ask for a return signature because most debt collectors only have PO boxes.
That's correct, yeah.
And for that sneaky reason, so that you can't do a cease and desist by. But there is in the U.S. mail, they have the certified where you don't ask for a signature, but you can still track it. But my personal favorite, that's the safest. What Mona said is the safest. My personal favorite is fax. If you have a fax number, it's instant, right? You send the fax, and you have the verification, so they can't dispute it. They know it was delivered, right? Mm-hmm. Now, don't forget. You break it, you pay for it. Strict liability. So technically, you send that letter, 5 minutes later they call you, well, yo and behold. What'd you have?
Violation.
I love that noise. What?
Violation, guys.
What was that?
It's a violation.
There you go. And also, if you don't have a fax number, but you have an email.
Email works too. You can do an email.
Email works too. So, and if they call you after the email, it's a
violation.
I love it. So we just talked about cease and desist violations. It's going to get a little bit more complicated, but not that much more complicated because, again, I don't want to talk legalese. So, Mona, misleading or false or misleading claims in an attempt to collect a debt. Like, talk to me about that.
So false claims, I think that's pretty straightforward. That balance that they put on there, that dollar amount that they put on there, I mean, it should be correct, right? If they send you the letter, it should be for that amount that you owe. If sometimes they, increase that number, inflate it, maybe it's been years, you don't remember what the balance is on the account, but that number is supposed to be correct, and it's supposed to be correct because they should have the records for it.
So let's give a hypothetical. So let's assume Mr. Smith, poor Mr. Smith.
I know. He's always the guy.
He's always the guy. So Mr. Smith owes $10,000. Mm-hmm. And, oh, by the way, I just thought of something. We have to explain that it has to be a consumer debt, right? Like,
that's right.
We'll get back to that in 1 second after the hypo. So Mr. Smith, right? Mr. Smith owes $10,000. And the debt collector decides to send a letter to Mr. Smith saying, you owe us money. Mm-hmm. And he says, Mr. Smith, pursuant to, your contract with Bank of America, or whichever bank Mr. Smith owed the money to, according to this contract, you ran up your credit card and you now owe us a total of $10,010. Mm-hmm. Violation or not?
It depends. So, I mean, if the creditor or the debt collector is allowed to collect interest on that account and interest is running on it, and maybe it's still in Bank of America's hands, and maybe this debt collector is just collecting on that company's behalf, then, it doesn't seem unreasonable that they would have some interest on it. But, it's got to be correct. If it's not correct, and, it really was $10,000 when the account got charged off and there's no more interest on that account, then, that's a false statement. He doesn't owe $10.
Right. So let's assume for the purposes of this hypothetical that the $10,000 includes attorney's fees and interest and everything that they were entitled to under the contract. But they put $10,010. Violation?
Violation.
Love that noise. Violation. No, but seriously, it's just $10, right? But like,
it doesn't matter. I mean, it's supposed to be true and accurate, and the statute says false statement. We talked about this before. If they're over the line, they're over the line, and $10 is not correct. It's a violation. Yeah.
So remember, strict liability. You break it, you pay for it. But I think, again, I want to come back to the conservative movement pushing back, going, really, you want to bring a lawsuit over $10? But it's not just about $10. And I think just on a more conversational and just like, I guess it's just opinion, and I guess that's what podcasts are for, but think about it though, right? Imagine if a debt collector collected $10 additional on everybody, right? Like, and you look at like companies like Midland Funding, Portfolio Recovery. These are big debt collectors that collect on millions of accounts. So assume a debt collector, and I'm not suggesting for a second that Midland does this or Portfolio. I'm just giving you examples of big debt collectors. But let's just assume a big debt collector, a hypothetical big debt collector, had 1 million accounts, and they decided to collect wrongfully $10 additional that were owed. They're collecting $10 million that's not owed to them in the cumulative. I think it's really important for people that are like more conservative minded to think about the cumulative effect. And that's another reason why this statute is so important, because it really sticks up for the underdog, where $10 actually means something. And like this particular issue, I argued in the Court of Appeals very recently, like a year or so ago. And actually, the appeals court judges, one of them, Judge Owens, in the Ninth Circuit Court of Appeals, he actually said it. He goes, $1 is $1. And he goes, you know what? People should pay their debts, but I don't want to pay $1 more than I owe. And that was in the oral transcript. And I think that was kind of telling, because when somebody at that level, in a federal Court of Appeals is saying something like that, they get it. And I think it's really important that people understand that this lawsuit is not just about $10. It's about creating an equal playing field for all debt collectors so that we have a fair society. That's what justice is. And so, like, justice is not just about murder and bringing those people to justice. We want a fair society in all. And that includes sticking up for the little guy, because $10 is $10 and it means something. And in the cumulative, across the board, it means a lot of, it means something. And that's just me on my soapbox today. But I really think it's an important issue. So we're talking about false and misleading claims. And I think that's a really, important part. But I think there's, let's talk about misleading a little bit.
Sure.
And the FDCPA, like I told you, the Fair Declaration Practices Act, ladies and gents, is not only a strict liability statute, but it's what we call a consumer remedial statute, which means that it's there to make it right for the consumer. And what is misleading, right? Because that's a subjective thought. But the law as it stands is not so subjective, because we've got some guidance on this, right? The law of the land is that what is misleading is looked through the eyes of the least sophisticated consumer. And Mona, you're going to tell everybody what that is.
The least sophisticated consumer is just, the regular average person, not, maybe the doctor that's in debt or somebody with a specific circumstance that's in debt, but just run-of-the-mill, average Joe, least sophisticated person, no special degrees in debt collection, regular guy.
Actually, I disagree with you. It's a lower standard than that. The Ninth Circuit Court of Appeals, and I don't want to get legalese here, it's our Court of Appeals, at least if you live in the Ninth Circuit, and it's pretty much the law in most of the land. And I mean, it varies a little bit, but at least in the large majority, it's the majority rule for sure. And if you live in California, Oregon, Washington, Alaska, Arizona, Nevada, all of these states, this is the law. The least sophisticated debtor standard is the most gullible of our society. It's not the reasonable prudence standard. It's not the average Joe. It's below the average Joe. It's the most gullible of our society. So that's really, really important, because a statement that may not be misleading to the average Joe or to a nuclear scientist or a doctor may be misleading to the most gullible of our society. And I'm going to give a hypothetical with that. So, first of all, let's assume you get and this tends to be more in letter violations, but it could be an oral representation too. But let's just get a letter situation. Client gets a letter and says, unless you pay us this debt, this debt will maybe reported on your credit report. And my client is a NASA scientist. Just saying, right? Now, That's not a false statement per se. It may be reported on your credit report. But the Ninth Circuit has said, and the Court of Appeals, I'm sorry. Check yourself. And so the Court of Appeals has said, you know what? It doesn't matter, first of all, that your client is a NASA scientist, because that's not the standard that we look at what's a misleading representation. We look at it through the most gullible society. So conditional language like may is not going to get the debt collector out of trouble necessarily. That's arguably a misleading statement because to the most gullible person, that may sound like a threat. Mm-hmm. Does that make sense? Mm-hmm. And so that could be a violation. I'm not saying it is a violation. I'm saying it could be a violation. And I think it's important that that standard, that you don't look at the mental state of your client.
That's right.
So if you're, and I'm sure most of you are very smart individuals, and you're thinking, well, I don't think this is misleading, but that's not the standard. You could still have a case, right?
That's right. It could still be a violation.
It could still be. And so that least sophisticated debtor standard, along with that strict liability standard that an FDCPA violation is measured under, is a very powerful tool to you, ladies and gents. So just because you think, well, that letter looks okay, doesn't mean it is okay. That's where probably you're going to need the assistance of a lawyer, I think. Mm-hmm. Now, again, our job here is to try and educate you. Do with that what you will. But I think this is where we get a little bit more technical. And even though we're not talking in legalese here, like we're trying to explain the rule so that you understand your rights. Because that's what's important here, is that you have rights when there's a debt collector coming against you. So talk to us, Mona, a little bit about things, like there's kind of two violations here. Things that the debt collector can do, but they don't intend to go through with it, and when they make that threat, mm-hmm. and threats that they make that they're not entitled to at law. And there's a slight difference there.
Sure.
So if you could give us like what it means and the hypo, all that.
So I guess I'll use the more common scenario kind of for both examples. So for example, either a debt collector sends you a letter or maybe calls you and says, if you don't pay by Friday, we're going to sue you.
Okay. When are you going to sue me?
If you don't pay by Friday, we're going to sue you. That means after Friday, most people would think they were going to be sued if they didn't get paid by Friday.
She's harsh. I better.
Or at least the least sophisticated consumer might think that. So, if they say they're going to sue you after Friday and they don't, and they had every right to, that falls under the first scenario where they were allowed to do something, they threatened they were going to do it, and they never followed through. And they probably weren't actually going to follow through. They were just threatening you to make you pay by Friday.
So they were just pretending.
Right. Or they may have wanted to sue you 100 years down the line, but, if they said they were going to sue you Friday, they scared you, you tried to scrounge up your money by Friday, and, you couldn't make it, and you were afraid you were going to get sued. You don't even have to be afraid you were going to get sued. Mm-hmm.
So under the least sophisticated debtor standard, that probably is a violation, but where it's even more airtight is where the debt collector calls you and says, unless you pay me by Friday, I'll sue you Monday.
That would be an even more, specific deadline, then yeah. Okay. And if they don't sue you by Monday, then that's definitely a violation.
Awesome.
So similar scenario, let's say that same debt collector calls someone on a very old debt and says, if you don't pay this debt, we're going to sue you. Maybe they don't give a deadline. They just say, if you don't pay this debt, we're going to sue you. But in reality, this account is very old. It's past what's called the statute of limitations, or the amount of time that maybe this creditor or debt collector could have sued you on this account.
Hold it right there. Time out. Statute of limitations. Go.
So the statute of limitations is basically the clock that starts ticking after the date of your default on this account. Your default meaning your missed payment. So in California, for example, and it may differ from state to state, but in California where we are currently, for example, it's 4 years. So after that 4 years has passed since you missed your payment on that account, a creditor or a debt collector shouldn't be able to legally file a lawsuit against you to collect it. That doesn't mean the debt goes away. They could still call you to collect the debt, but they shouldn't be threatening to sue you on it. And that's where that second example comes in, where they threaten to do something. They may or may not have intended to do it, but they're not allowed to threaten that at all. They're not allowed to say that we're going to sue you to scare you to paying that debt, because they're not allowed to sue you on an account that's that old.
That's really good. Thank you. So, what we've done right now is kind of gone through the more technical and the the things that you may not have thought or known about when it comes to abusive debt collection practices. Because like when people talk about abusive and unfair debt collection practices, they're thinking about somebody getting violent with you and stuff like that. But that actually is a violation.
It still happens, I think, some places. You hear about it every now and then.
Yeah, racial epithets.
Absolutely.
Profanity.
Absolutely.
Screaming.
Yeah, still screaming, yeah.
Screaming is a violation?
I mean, usually it's tied in with profanity and maybe, some derogatory other statements along with it. I mean, usually you're not just screaming and saying nice things, but,
Yeah.
That's why we have to look at it, on a fact-specific basis and get the whole story from a consumer before we can say whether it's a violation or not.
Okay, what happens? They'll go, God damn it, Mr. Smith, you're a goddamn deadbeat. You need to pay me by Friday.
I think that could be a violation.
I think it is a violation.
Yeah.
I have a more
I think it could be a
loosey-goosey standard than Mona's hard. You can't call someone a deadbeat.
No, definitely not a deadbeat. I mean, cursing at them, using, sometimes it's, racially charged or offensive words. These debt collectors say what they have to say and, push the right buttons to try to get people to pay them, unfortunately.
Okay, true story. We had a case in San Diego, and we got one of our partners, David, in the back here, right, watching
Hey,
today.
Dave.
I'm not sure if you remember this case. So our client you're not going to believe this. So our client goes to a secondhand car dealership in San Diego. Do you know this one? Dave knows this one. And our client was black. And the salesman kind of like conned her into buying a car she couldn't afford. But lo and behold, she does anyway. And sure enough, she finances it and can't make the payments. She defaults. Well, guess what happens? The same guy decides to call my client and on a voicemail drops the N-bomb over 40 times. I mean, this is in the 2000s. This is the society we live in. Yeah. And people think, oh, it's far-fetched. Who's going to do that? Well, it happens. And I'm kind of on my soapbox today. Again, I get a lot of grief from people about the use of the statute in trying to make things right for the underprivileged, the people that can't afford to pay their debts, because they're not all deadbeats. And then these people are human beings, they have rights, and nobody has the bloody right to call any other human being, drop the N-bomb on them, call them these kind of names. But unfortunately, we live in a society that still happens. Mm-hmm. And that's why this statute is so important. And again, one of the main purpose of this program is really to empower you. Nobody has the right to speak to you in that regard. And if they do, you have absolute rights under the statute in the debt collection context. Nobody ever should speak to anybody else like that. But you have a cause of action, guys. And that's just nonsense. And it's beyond insulting and profane and I don't know. I just get worked up when I even talk about it. I mean, I laugh about it at the beginning because it's just so abstract and crazy to me. But when I actually get to think about it, it's actually so offensive, mm-hmm. Beyond offensive. Mm-hmm. Anyway. What about immigration, threats of immigration and law enforcement, district attorney and all that kind of stuff?
A debt collector might threaten someone who they think is afraid of being deported, for example, or someone who maybe they've seen has a certain status in this country. They push those buttons. They say those things to scare a consumer into paying them, sooner rather than later for their own benefit. Maybe they'll say the police are going to come to your door, or we're going to send a sheriff over, or you're going to be arrested, or there's 100 ways they could say it, I suppose, and I think we've heard them all. But none of these things are, proper conduct under the law, and they're definitely violations of the FDCPA.
Right. And I think this is a big takeaway because a lot of people that come to this country from other countries, they're used to systems where debt is potentially a criminal act, mm-hmm. and if you don't pay your debt. In America, civil debt is exactly that, civil. Nobody can arrest you for owing a credit card debt or a medical bill or something like that. You're never going to get arrested for that. It's a civil issue, and if anyone ever makes a threat to deport you, have you arrested, get the sheriffs involved, get the district attorney involved, you need to immediately protect yourself under the statute, because it's absolute nonsense. And yes, it does happen.
Absolutely. We hear it all the time.
We've had clients, it's an absolute reality. I honestly don't think we can explain letter violations like on a show like this.
I think it's hard to explain without, putting a letter in front of somebody and pointing at something or showing about 100 examples of, what might be a violation and what might not be. So that might be a little bit hard to talk about during today's sort of program.
I totally agree. And I think, here's the interesting part. Like I told you, through our experience, maybe 70, 80% of the time, when people try and collect debt from you, they're probably doing something wrong. Not always, but probably. Most people that do this area of law throughout the country, and I'm going to give you a website that you should go to. Is it NACA.com or NACA.org?
I think it's NACA.net.
NACA.net. That's NACA, National Association for Consumer Advocates. NACA.net. Go to that website. It has a lot of useful information anyway. And it also lists lawyers around the country where they do this exact area of law. And nobody in that organization should really be should be charging for this service. They do free consults, and what you should do is, if you get a letter from a debt collector, it's going to cost you nothing. Just call a lawyer, get a free consult, and they'll review the letter for you. And if there's a violation, again, they should be working on contingency. They shouldn't be charging you anything up front. And so my position to you is, if you're getting debt collection letters, use that ability to go to that website. There's a lot of good resources on there, and they're going to be able to, some lawyer in your local area is going to be able to assist you. Now, let's talk about before we move on to damages, I just want to say, what we've talked about is not exhaustive. It's not, like I told you at the beginning of the show, there are 1,000,001 ways that debt collector could violate the FDCPA. There's just too many ways because it's such an elastic statute. It's very flexible, and it has catch-all sections, meaning if the conduct of the debt collector is perceived to be unconscionable or misleading or false or deceptive, these are what's called catch-alls. Under the purview or through the lens of the least sophisticated debtor and that strict liability standard, you can make a lot of things a violation. You have a lot of rights. So you can use those catch-alls to make a myriad of different conduct and actions or inactions violations. So if you're not sure, contact someone, go to that NACA website that I told you about, find a lawyer in your area, and they'll be able to assist you. Now, damages. What is a consumer entitled to, Mona, under the statute if there is a violation?
So under the FDCPA, if there is a violation, the consumer is entitled to up to $1,000 and their reasonable attorney's fees and costs, as well as any actual damages and that's kind of one of those legalese terms, but any other damages that might have happened because of this are unfair debt collection.
Let's break it down. Let's go with statutory damages of up to $1,000. Statutory damages are damages that are given to you and you're entitled to by statute.
That's correct.
That means that statute, the 1692, the one that we talked about, says you're entitled to up to $1,000. Now, is it per violation or for the totality of the conduct?
No, unfortunately, it doesn't stack per violation. It's up to $1,000 for the totality of conduct by each debt collector on that account, if it were.
Yeah, so if there's 3 debt collectors that are committing violations, you're allowed up to $1,000 from each of them.
That's right.
Okay. Now, let's talk about actual damages, which is, like you said, legalese. Mm-hmm. So these can include economic damages, which is kind of out-of-pocket damages, mm-hmm. right? So what could be an example of that?
Maybe it's damage to your credit. Maybe it's, you had to maybe take out a quick payday loan to pay that debt collector, and they were lying to you about something. So, you took out this other loan, you got interest. Maybe you got dinged on that other loan because of this whole thing. It kind of depends on the whole story surrounding it and what happened to you because of this debt collector.
Right. You may have had some medical issues, like, somebody got sick because and anxiety, and you had to pay for your medical expenses.
Right. Or it could be, that extreme where, maybe unfortunately, it does happen to people. Some people maybe have like a seizure. They could have a panic attack. They could, God, I hope it doesn't happen to anybody, but they could have a heart attack. And I mean, that shock of a debt collector scaring you could do a lot of things to different people. So,
Sure.
you know, I hope that doesn't happen to anybody, but those are certainly examples of, you know, because of those medical bills that'll arise after that, and of course the harm to your personal self as a result of that stress, or maybe you see a psychiatrist or psychologist because of the stress too, or anxiety. Those could all be actual damages.
Right. Now, on top of that, there are things that are not quantifiable that are under the label of actual damages, like anxiety, stress, humiliation. Like, how can you be humiliated? Well, I told you, we can't go through every subsection of the FDCPA, but a debt collector can never, unless they're your spouse, that's the one exception, unless they're your spouse, they cannot disclose that you owe a debt to third parties. If they do, even if it's your children, your parents, your neighbors, that's a violation. And why? It's because what the debt collectors are trying to do in that regard is when they disclose, they're trying to embarrass you into making that payment. So that is actually part of the instructions a jury would get in a trial situation, where it says, if you feel like that Mr. Smith was humiliated in this scenario, you should compensate him for that. And that's really, the amount up to that is uncapped. The jury can say it's nothing, it's $1, or it's $1 million. So, you know, stress, anxiety, it's just emotional harm and things like that. I mean, this kind of conduct really does affect people's lives.
Absolutely. It's hard to say what that dollar figure should be exactly in front of that, but it absolutely affects people's lives. And unfortunately, that's one of the most popular, I guess let's call it, violations of the FDCPA by debt collectors. They like to call other people. They like to scare you or embarrass you or threaten you into paying this account because they think that, you know, the more pressure you feel, the faster they get that money in their pocket.
Okay. And then lastly, on the damages front, you pointed out attorneys' fees and costs.
That's right. So that's one of the great reasons why attorneys like us and a lot of the attorneys that we know that practice in this area of law are able to take these cases, I guess we would call it on contingency. I think a lot of people are familiar with hearing it that way, meaning that we don't charge you anything up front. If you get paid, we get paid, basically. So if there's a result that's profitable from the case, then, you know, that's usually how these attorneys will get paid, and that's, you know, how they do it on contingency. But that means that you were saying that they get attorney's fees and costs. The defendant or the debt collector here, if they're found to be in violation, should have to pay your reasonable attorney's fees and costs. So, you know, whether it takes, you know, a month or a year to litigate your case, then if they're found to be in violation, they're on the hook for that.
Sure. And so, like, and I think we've talked about this in our other podcast, which is 99% of cases don't go to trial. So we don't have to necessarily win at trial to get our attorney's fees from the defendant, right?
Sure.
So part of the negotiations when we're trying to settle a case is that we're like, well, yeah, even though it's a compromise, we want X for our client and we want X for or Y for our attorney's fees and costs, because if we were to go to trial, we would be entitled for that, and that's how the settlements work.
Oftentimes, that's how it goes.
Right. And so just the last practice point, and we're running out of time here, is if you live in California, nowhere else California, there is a sister statute called the Rosenthal Act, or the RFDCPA, which is the Rosenthal Fair Debt Collection Practices Act. And it, for the purposes of this podcast, and again, it's very, very kind of generalized here, the same rules apply, but the beauty of this statute is
that it has another section of damages under that statute, that, you know, if they're in violation of both the Rosenthal Act or the RFDCPA as well, the FDCPA, then the consumer could get the benefit of up to $1,000 under each of the statutes, plus their attorney's fees and costs and actual damages.
Which is 100% true. But also, the original creditors, which are not covered under the FDCPA,
that as well,
they don't get shelter in the state of California. All the conduct we have discussed covers original creditors in the state of California. So people like Citibank, Bank of America, American Express, you name it. If they're the original people that lend you the money, they do not get to be protected from the conduct that we've discussed because they're the original creditor. They also get to violate a statute if they do any of the stuff that we have discussed, and it's almost like a shadow statute.
Nearly every section of the FDCPA is incorporated into the Rosenthal Act. So
Exactly right.
anything that a debt collector might have done that's perceived to be a violation is most likely a violation under the Rosenthal Act as well.
Right. So in closing remarks, guys, this is a really, honestly, I really urge you to go rewatch it, re-listen to this. It's a very, very important statute. It's important for society as a whole, and I think it's an area of law that a lot of people in this country are affected by. If you're not in debt yourself, you probably more than likely know someone, your friends, your family, your neighbors, and please pass on the message that they have rights. If you've got any questions, you know the usual email. It's going to be on the YouTube channel. You can go there, email any questions for next week, and until next week, guys, keep it legal.